Very good to be with you tonight. And you know, when I walk into a room like this, I certainly sense one dominant sentiment, and it is that the American people haven't gotten soft, but our politicians' commitment to the Constitution has gotten a little bit soft. A little bit, yes, a little bit. Even before taking on the typical prosecutorial duties you expect of an attorney general, the first thing in my oath that I swore was to defend the Constitution of the United States. And when the federal government decides to break the law or overstep the boundaries of their constitutional authority, of its constitutional authority, I'm going to push back. That's what I said in my campaign. And the federal government seems to be doing a bit of that lately, so I've been a little bit busy. Boredom has not been a problem in my office. Thank you, Mr. President. Our country's founding fathers pledged their lives, their fortunes, and their sacred honor to defend the principle of liberty. They created a government of limited powers to secure that liberty and to protect the rights of the people, the citizens. They didn't create a government to add more power for itself at the expense of the people. But although our federal government was created with limited powers, we as a people have frequently demanded that government take care of more of our problems, our challenges, and it was willingly grown to accommodate it. And in the process, those limited government principles were shoved aside. We've asked government to do more for us, and each time all the government asks for in return is just a little bit more of our liberty. One little bit at a time. And over the decades, we kept asking. And because the courts and politicians were only too happy to oblige and often encourage this course, regardless of what the Constitution said, regardless of what the founders had taught us, we now no longer have a federal government of limited powers. We have a central government, a government that exists in its mind, in its operation to plan and control every aspect of our lives and our economy, be it healthcare, automobiles, banking, and the list goes on and on. But as our founders did, we're beginning to push back. This gives me actual hope, not the kind you heard about in 2008, but real hope. With this pushback, we're seeing federalism reemerge. We're actually seeing it discussed publicly. It used to just be in classrooms. And this is where states are serving as a check in the check and balance system against the federal government when it oversteps its constitutional boundaries, just exactly as the founding fathers intended that we would do, exactly as they would intended. You're all familiar with the separation of powers. Federalism is the vertical separation of powers between the federal government and all the states. The founders created it as a fail-safe, as a backstop to prevent the federal government from becoming so powerful that it would be destructive of the very liberty it was instituted to protect. Federalism is a lot more than some classroom talking point. We've just witnessed a federal health care bill that passed against the will of the majority of Americans at the time, and it's an even bigger majority now. But more critically for me, as an attorney general, it was passed and it violates the law, the Constitution, the document that governs government. It's supposed to, anyway. And we are now more than half the states are taking the government to court over it. I'm not aware of any time in history when this many states have sued our own federal government over the same issue. And think about what we're doing. We are suing the federal government to protect the U.S. Constitution from the federal government. It's a pretty unbelievable thought, isn't it? But again, that's what the founders had in mind. Virginia was the first state in the nation to argue in federal court that the new health care law is unconstitutional, just as Virginia was the first colony to proclaim give me liberty or give me death, 235 years to the day before the president signed that health care bill. Now, we waited about 15 minutes to file suit, and it occurred to me that night on a teleconference that we filed our suit on Broad Street in Richmond, 17 blocks west of exactly the same spot where Patrick Henry spoke that speech 235 years before. And this bill is the greatest erosion of liberty that we've seen from our federal government in a long time. I know whose side Patrick Henry would be on. When we brought suit in March of 2010, most media outlets and many legal experts, got to use the air quotes for some of these legal experts, said we didn't have a chance. One law professor said our argument was, if not frivolous, close to it. Another one said that our case relied on a controversial reading of the Constitution. Yeah, now you have to go to an Ivy League law school for an awfully long time to think that it's controversial to apply the Constitution as it was written. Unfortunately, some people go to Ivy League law schools that long, and then they head to the federal government, it seems. But back in December, last December, when a federal judge ruled in our favor that the individual mandate of that health care bill was in fact unconstitutional, a lot of those legal experts and media pundits got a little bit quieter. But no one should have been surprised that we prevailed. No one should have been surprised. Our argument is simply that government and their attempt to use the Commerce Clause to mandate, to dictate that people buy a private product, something they've never done before, and in this case it's health insurance, goes beyond Congress's power under the Constitution. The federal government can tax you, they can do many things, but they can't force you to buy a product under the guise of regulating commerce, and they never have before. There's a reason there's never been a mandate like this before, because every president and Congress before this one knew they didn't have this power. They knew they didn't have this power. I often refer back to the days when we were colonists boycotting British goods to demand that King George III and the Parliament of Great Britain repeal the Stamp Act of 1765. That went on for the 10 years leading up to the Revolutionary War. 10 years. At that time, the King's Attorney General and Solicitor General, by tradition, sat in Parliament. And they were asked by members of Parliament if the colonists' boycott of British goods was treasonous. The answer was that the colonists have come up close to the legal line, but remained within it. And this was a tacit concession. If you flip this coin over, what they're conceding is that they couldn't order British colonists, American colonists, to buy British goods. King George III and the Parliament of Great Britain that we rebelled against understood that they could not order American colonists to buy British goods, but we have a president and had a Congress in 2010 that believe they do have that power. That is how historically stark this exercise of power is by this federal government. And that was when we were subjects, not citizens, subjects of the king. The federal government's argument is that your decision to do nothing, to not buy health insurance, is economic activity. You know, if I wrote this as fiction, no one would believe it. The government says that it has the power to regulate your decision, your thought, under the Constitution's Commerce Clause. One of the judges that ruled for the federal government referred to it as regulating mental activity. You know, George Orwell's thinking, sequel, sequel. So in the government's dictionary, doing nothing, inactivity, is the same as activity. In other words, the government has the ability, as they see it, to regulate you for doing nothing. That same reasoning could be used to order you to buy a car, asparagus, a gym membership. Those are the examples the judge in our case used in court. And they are not at all far-fetched. If Virginia loses this suit and our sister states, and the federal government is allowed to cross this line, Congress will be granted a virtually unlimited power to order you to buy anything in the name of what it determines is the public good. You'll be a subject, not a citizen. That's why I've said from the beginning that this lawsuit is not about health care, it's about liberty. That's what's at stake. Now, I want to tell you about a recent decision we had in the Fourth Circuit Court of Appeals, which is the court below the Supreme Court for Virginia. I want to tell you because it was such a stunning decision. The court threw our case out, saying that Virginia didn't even have standing to defend its own code of laws. That if Virginia could bring a lawsuit like this, it would mean states would be acting as constitutional watchdogs over the federal government. Sounds like a pretty good idea to me. Well, that decision is 180 degrees from the founding vision of the role of states. The states are supposed to act as constitutional watchdogs over the federal government. Just as, and this is intentional tension, just as occasionally the federal government checks unconstitutional acts of states. It goes both ways. They're not used to the federal government being challenged, however, but that's the system our founders set up. That conflict is what federalism is for. It's what it is, in essence. There's no other appellate court, forget healthcare, that has ever denied a state the ability to defend its own code of laws. Never. Never. It's a kind of dismissal of a state's role in our constitutional system that is just unprecedented. But it's what you'd expect in a country of subjects, not citizens. That's why we're not only asking the Supreme Court to review the constitutionality of the health care mandate, but also this ruling that says states don't matter in protecting liberty in their own codes of laws. Ladies and gentlemen, the health care case is just one of the fights in Virginia's federalism fights with the federal government. Even before the health care suit, we were pushing back against the EPA, or as I like to call it, the Employment Prevention Agency. It's what they do best. So 2 years ago, the EPA declared carbon dioxide a pollutant dangerous to public health. Now, of course, what you need to know is carbon dioxide is keeping the trees alive that create the oxygen we breathe. And of course, we're all exhaling it right now, so let's all just together annoy Lisa Jackson, shall we? Ready? 1, 2, 3. Excellent. Thank you, thank you. And now all of a sudden, it's a dangerous pollutant. This new regulatory scheme is going to have the same results that the Waxman-Markey cap and trade bill would have had, including the ensuing economic damage. According to the Heritage Foundation, cap and trade was projected to cost every household thousands of dollars a year, as everything that took energy to manufacture or to transport would increase in price. Food, clothing, building supplies, pretty much everything. The cap and trade style regulations the EPA wants to foist on the American people would also chase industry and jobs out of this country. And our loss would be China's new jobs program. We need a jobs program for this country. The EPA has issued these regulations without regard for economic impact, and again, critically for me, as an Attorney General, in violation of the law. In violation of the law. It delegated research authority to, of all entities, the United Nations, rather than doing its own research. And the agency also relied on data from the scientists exposed in ClimateGate, who intentionally manipulated data to come to a predetermined conclusion about the causes of global warming. Now, I've been hammered in the media for a year and a half for challenging the EPA, and I've been accused of being anti-science, and you can imagine all the other wonderful adjectives. But no doubt from scientists who attended the same universities as those constitutional experts from the healthcare case. But yet an incredible revelation came out just last week that supports our case. The EPA's own Inspector General, their own Inspector General, issued a report last week that agrees essentially with what we've been saying all along, that the EPA failed to determine the accuracy of the outside data that it used to conclude greenhouse gases were a danger to human health. The EPA rushed to create a new and unprecedented power for itself to foist over the American people and the economy, and it shortcut several procedures and policies to do it. That's the way a government treats subjects, not citizens. I've asked the EPA since February of 2010 to simply reopen its hearings and review its findings while following the proper rules and procedures, what many of us call the law. I've also asked the EPA to allow new and conflicting evidence from ClimateGate that's become available since the original decision. When the agency refused, we and more than a dozen other state attorneys general, Republicans and Democrats, filed suit and asked the court to compel it to do just that. We're now filing our last brief in about a week and a half, and we'll await a hearing and decision in 2012. It's going to be a big year. The bottom line here is that the EPA's failure to follow its own rules calls into question everything that it's done. True science is testable and verifiable, and true scientists willingly show their work and allow others to test their data, their hypotheses, and their conclusions. Whenever a government agency, some of these folks have embarrassed their fellow scientists. Whenever a government agency states a conclusion that's allegedly based on science but refuses to comply with its own rules that require it to show its work, we should all be concerned. But the government overreach doesn't stop with healthcare, and it doesn't stop with the EPA. There are others. It is really amazing how many more there are. On the labor front, Virginia is working with South Carolina Attorney General Alan Wilson and more than a dozen other state AGs to fight the National Labor Relations Board in their attempt to shut down a $1 billion Boeing factory. They're going after Boeing because they had the temerity to expand their facilities in a right-to-work state like South Carolina instead of their unionized plant in the state of Washington. For those of you who don't know what right-to-work states are, there are states where a worker can't be forced to join a union to get a job at a unionized company. Imagine that, freedom. In this country, there are 22 right-to-work states. Virginia is one of them, South Carolina is another, and it's the worker's choice to join the union or not. In the other states, it's join the union or don't get the job. Contrary to the NLRB's allegations, Boeing isn't getting rid of any jobs in Washington. They're expanding their Washington plant while building the South Carolina plant. So why are they doing this? The NLRB complaint is really just pandering to union bosses. The complaint shows a total disregard for the facts and the law, again, and is an assault on the ability of our right-to-work states to create jobs, recruit industry, and practice freedom. It's also an assault on our citizens' right to work without joining unions. But that's how you'd expect the government to treat subjects, not citizens. The government is also attempting to impede the mining business. I'm sure that's no surprise. I'm from Virginia. We're a coal state. 18 others like us have been granted for 35 years the exclusive, that's a key word, exclusive right to regulate surface mines in our states. And we have done that responsibly in Virginia. But in January, the Federal Office of Surface Mining, which you'd probably never heard of before, the OSM, created aggressive new directives to essentially interfere with the state's exclusive responsibility. The problem is they have never been given this authority by Congress. Their directives are, however, consistent with President Obama's use of administrative agencies to accomplish policies that he couldn't possibly get through Congress. You may recall he said he wasn't averse to putting the coal industry out of business. Well, he's doing his best to do that. Virginia's urged the OSM to step back, and if they don't, we know what to do. We know what to do. In Virginia, we refuse to be treated as subjects, not citizens, by the federal government and by the OSM bureaucrats. And as bad as those overreaches are, one of the most egregious yet comes from the FCC, the Federal Communications Commission, which wants to regulate internet traffic by imposing so-called net neutrality regulations. Now, you know, whether Republicans or Democrats are in charge in Washington, when they call it net neutrality in Washington, the one thing you know is that it is not neutral. Whether you like net neutrality or not, it has two very big problems. First, the agency didn't have the authority to do this, and second, and much more critical, is that a court has already ruled that they don't have the authority to do this. So now, in addition to disrespecting states, the Constitution, federal law, when it's inconvenient for them, they are now defying their own federal court's orders. This is the high watermark of the disdain of this administration for the rule of law itself. And, you know, is it something you'd be surprised with if you were a subject, for instance, rather than a citizen? The law applies to all equally. In all these scenarios, EPA, NLRB, and all the rest, I want to keep you in mind of another very important point, and I want you to share it with other people. And that is that the people hurt first and the worst by this sort of regulatory onslaught are the poor. While liberals claim to be compassionate toward the poor and demonize conservatives for allegedly not caring, most of the liberals' intrusive and expensive regulatory schemes hurt the very people they say they're for. The poor are the least able to pay when the cost of goods goes up. They have the least ability to change jobs. They have the least ability to move when you shut down an industry in a whole region of a state. The poor also experience the greatest job losses when factories are closed or downsized due to punitive regulations and onerous burdens on industry. This is one thing that we have to keep in mind and can't let others forget. It's conservatives who support the free market and the opportunity and liberty that comes with it who support the poor. With all of these agencies and others, the Obama administration is aggressively using their agencies to accomplish policy objectives they could never get through Congress and are frequently outside the law. The administration has shown its disdain for states, for the federal laws, for the courts, for the Constitution. It is truly unprecedented to see such an across-the-board disdain for the rule of law itself in our lifetimes. We all have to take a stand. I'm working with attorneys general across this country because when you don't have enough constitutional conservatives to rein in the federal government in Washington, it is state attorneys general that are the last line of defense. There are some who say the Constitution is no longer important. Our founders are accused of not possibly knowing about issues we'd face today like healthcare costs and the internet, but I'll tell you what, the founders knew about tyranny. They knew about tyranny, and they created a constitution to limit government precisely to keep that government from accumulating the kind of tyrannical power that we rebelled against 235 years ago. And they did it to ensure that the generations that followed would be citizens and not subjects. Ladies and gentlemen, it's important to remember that more than 1 million people have given their lives over the history of this country to establish and defend our freedom. Fortunately, no one in this room has to sacrifice anything so precious as those patriots did to preserve the gift that they passed on to us. For us, it's as simple as getting off the couch, volunteering in campaigns, talking to our friends and family, and yes, writing checks, There's no danger for anyone in this room who does that. And there's too much at stake to stay home and sit idle. Too much at stake. Ladies and gentlemen, we are still fighting the same battle for freedom the founders fought 235 years ago, and that's because, like them, we stand here choosing to be citizens and not subjects. Subjects get what the government grants them. Citizens give government anything that it's going to get. And that's America. Thank you all very much. May God bless you and may He continue to bless this amazing nation of ours. Good night.